We have breaking news out of the United States Supreme Court. The Supreme Court this morning issued their weekly orders list. Their orders list. As a reminder, the order is different than an opinion. The Supreme Court in today's order list did not mention any Second Amendment related case. This is not necessarily bad, but we're going to break it down as to what it means for the quote-unquote assault weapon bans out of Illinois and whether or not we think they can still be granted cert and heard by the Supreme Court next term. Talk about it in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, so we have breaking news in a sense that there's no news, but no news when you're dealing with the U.S. Supreme Court is often news. Specifically, the U.S. Supreme Court this morning after Memorial Day issued their orders list. As a reminder, an order is a directive from the U.S. Supreme Court telling one to do something or to not do something. The orders list are very important for determining which cases the Supreme Court hears, because if they're going to grant cert, which means they're going to hear the case, it will be in the form of an order. If they're going to deny cert, which means they're not going to hear the case, that also will be in the form of an order. That is different than an opinion where they indicate who wins the case on the merits and why with a big rationale, like NYSERPA versus Bruin, for example, is an example of an opinion, but the order is different in the sense that the order tells people whether or not, in this context, cert is granted, and that's what you need to know here. So the order list is today. The opinion list is coming out on Thursday. New opinions will be out on Thursday. But as to today, what we're looking for in these order lists is whether or not the U.S. Supreme Court is going to hear one or more of those 6 pending quote-unquote assault weapon ban cases out of the state of Illinois. There are 6 pending petitions waiting for a determination as to whether or not the court will grant cert and hear them. This was initially listed for conference, which means a conference is where the Supreme Court justices by themselves, by the way, with no clerks or anyone else in the room, the 9 justices come together and conference whether or not to hear a case. It takes 4 justices to vote to hear a case to grant cert. And sometimes, as I've explained to you, a case can be relisted or conferenced multiple times before a final decision is made. Now, the Illinois cases, which we'll go over in just 1 second, they have been conferenced at this point twice, I believe twice, which means they were initially conferenced. There was no order, meaning yes or no as to whether or not the court will hear the case once. Then it was relisted. They had another conference last week as to whether or not they would hear one or more of these 6 quote-unquote assault weapon cases involving magazines and semi-automatic rifles. Still no decision, at least publicly. So what does this mean? I think it can mean one of several things, and let's go through what it might mean. First of all, it may mean that the Supreme Court has simply not decided whether or not to hear one or more of these 6 cases. They may still be saying, look, we think we may want to hear these cases, but we got to make sure we know what the case is going to be about and how it's going to go down, because a lot of time justices do not want, even if they support a case, they do not want the case to be heard if they think that the case will come out a way they don't want it to come out. And by that means either the party they think should win the case will lose the case, or they might think that the party that they think should win the case will win the case, but the legal rationale or the opinion they anticipate being drafted by the court may not be conducive to what they think the law should be. So there are instances where justices may want to grant cert in a case, but because they're not confident, they can ultimately win the case on the merits in a sense, or they're not confident that the language of the opinion to be written as part of that is what they want, they might even decide to vote against it. So right now, it's possible that what's happening on the Supreme Court is they're trying to figure out, do they have 5 or more justices that are willing to rule, for example, hypothetically, in favor of the Second Amendment, to say these assault weapon bans are unconstitutional, and at the same time trying to figure out if they are going to issue such a ruling, what do they think the rationale or the opinion might look like? Because remember, the Supreme Court, it's not just about who wins the case. That's very important, of course, but it's also equally, if not more important, as to how the case is won or lost, because it's the long 70-page opinions that lay out the law of the land that the lower inferior courts will follow. So again, what may be happening now is the court may be trying to figure out, do they have 5 votes to issue a ruling one way or the other, and what might that opinion say? That's one possibility of why the case is being relisted and no cert decision has been made one way or the other. The second thing that might be happening, of course, is they may have internally decided they are going to grant cert in one or more of these 6 quote-unquote Illinois assault weapon cases. And what they're doing now, and this is a very big, this is inside baseball for all you out there, Chief Justice John Roberts has been very persnickety on one thing. The last thing he wants to do, because the court takes so few cases every term, is he doesn't want to use one of his cert grants in a case and then find out 6 months later there's a procedural problem with the case, either because the plaintiffs don't have standing, there's a lack of subject matter jurisdiction, which can always be raised. There's a case or controversy problem, which means maybe they don't have jurisdiction over the case. There could be a mootness problem, whatever it is procedurally, or maybe for whatever reason the nature of the parties are such that they're not going to get a clean opinion out of the case, and they may wait for a different kind of case to come down the pike. But whatever it is, it's possible that the Supreme Court has already decided to hear these one or more of these Illinois cases and are simply right now trying to figure out, is there any procedural problem with one or more of these cases? And they might even be saying, well, we got 6 cases here. Which do we think is the best 1 or 2 cases of the 6 to grant certain, and simply take the other cases and hold them in abeyance on a shelf while we decide the cleanest case? So that could very well be the case right now. They may be looking at the records of each of these 6 cases to decide which is the best vehicle to grant cert based on the record of each of these 6 cases. That could also be happening. In other words, they may decide they may have already decided we're going to grant cert and hear one of these assault weapon cases. We just need to figure out which of the 6 or more, one or more of these 6 we're actually going to hear argument on, because that will set the precedent for the others. The other thing, of course, and this is getting down the list of things that might not be very good for us, there may be a decision that they're going to deny cert in these assault weapon cases, these semi-automatic rifle and magazine cases, on the grounds that this is at a preliminary interlocutory stage, because it's on a preliminary injunction basis. A full record has not been developed. I don't think you need more of a record than this for a bunch of reasons we've talked about in the past. I think basically just Judge Easterbrook and Judge Wood are just trying to drag their feet and delay in favor of gun control, as we've talked about before, out of that U.S. Court of Appeals for the 7th Circuit. But the bottom line is it's quite possible that the U.S. Supreme Court has decided they want to deny cert in these cases because they're prematurely up there, because they're on a preliminary injunction. There's no final judgment. They're what's known as interlocutory. So it's quite possible the Supreme Court has decided they're going to deny cert in these cases, but one or more of the justices might want to write a concurrence, for example, that says, hey, we're denying cert now because the procedural posture of the case, i.e. no final judgment on a preliminary injunction, the case is sent back to the district court for more fact-finding. We think this is an appropriate case at some point to hear, but for now, we're not going to hear it because the posture is not wrong, is not right procedurally. And then they might go on to write something favorable for us. They would say something like, look, here's some general guidance that we think might be helpful for the lower court. And maybe they will reiterate the in common use test. I don't know. It's a possibility that you could get a denial of cert with one or more justices given a concurrence, sort of saying we agree with the denial of cert, but we want to give the lower courts some thoughts about how we see this case, so don't screw it up. Now, the last possibility, and this is the worst possibility for us, is that there is a delay going on here, that the court has already decided to deny cert in this case. But again, one or more justices are taking time to either write that concurrence I just referenced or to write a dissent. It's not unusual if the Supreme Court decides to deny cert in a case that one or more justices that disagree with it and they think the court should have granted cert, they can write a dissent in opinion saying, we think, or I think, that cert should have been granted here. Here is why it should have been granted, and they could write that dissent. The reason why this concept of a concurrence being written by one or more justices or a dissent being written by one or more justices is relevant to what's going on here is it is a possible, not the only, but a possible explanation as to why these Illinois quote-unquote assault weapon cases are being relisted and reconferenced. It could be any of the different things that I've just articulated, some of which are very good, which is they're going to grant cert and they want to make sure the posture is correct and they want to get the right case. Or it could be kind of bad, which is they're going to deny cert, and someone like Justice Thomas or Justice Alito, hypothetically, might be writing a dissent now explaining why this is BS. And of course, it takes time to write a dissent or a concurrence, and that may be why they're delaying the ultimate denial of the cert to give one or more of these justices the time they need to write the dissent, so that when the order comes out denying cert, there will be an opinion attached to it. And of course, opinions take time to write properly and get your cites right and all that sort of stuff that takes a bunch of time. Now, with that said, I do want to give you a very interesting observation. I saw this on X by a very astute commentator. They flagged this on X that in a prominent website devoted to the Supreme Court practice, if you will, called SCOTUSblog. SCOTUSblog, very well known. A lot of the law clerks and probably the justices do pay attention to SCOTUSblog periodically. This is very interesting. They had an article that just came out. I'll put a link to it down below. And it talks about these 6 petitions seeking review of the determinations of these cases involving the Illinois quote-unquote assault weapon ban and or the magazines. But here's the key sentence that was written on SCOTUSblog, and it's extremely helpful to the Second Amendment community, given the language. Let me read it to you, and I'll put it on the screen so you can check it out. This is what SCOTUSblog said in describing these pending petitions for cert in these quote-unquote assault weapon cases. Given the ubiquity of AR and AK-type firearms, this case will likely be a blockbuster if granted. Well, I agree with that, but the funniest part about it is that really, if this case is granted, it's going to be a layup, because it's crystal clear that under the Supreme Court precedent of Heller, reaffirmed by Bruin, that the anti-gunners, in my opinion, have no chance on any of their semi-automatic rifle bans. They have a small percentage chance if there is cert granted on a magazine. I don't think they have much of a chance on the magazine argument either, but I think basically if cert is granted in any of these cases out of Illinois, and I'm not sure it will because of the procedural problems we've talked about because they're interlocutory in nature, I think this will be very, very close to an absolute slam dunk in favor of the Second Amendment. And I've got some other thoughts about what may have happened back in 2016 involving AR bans, but we're going to talk about that in a separate video because it's something I've connected some dots with that you're going to be surprised by, or maybe you won't be, but it's quite fascinating when we talk about something that happened in 2016 and the Supreme Court with quote-unquote assault weapon bans. But for now, let's just talk about what happened today. The bottom line is we're in a wait-and-see posture with these Illinois cases. We hope and pray, in my view, that the Supreme Court takes one or more of these cases, because if they do, I think the odds of us winning this case and knocking out these bans of ARs and AKs is well over 95% that we will win this case if we can get them to take it on the merits, which is what we're hoping and praying occurs right now. At least I am, from my point of view as a supporter of the Constitution and the right to keep and bear arms and the entirety of the text of the Constitution. All right, folks, hope you learned a little bit something here today. Make sure you subscribe and follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.